when you look at a massive skyscraper, you really just see the glass and the steel, right?
Yeah, totally.
You see this finished product gleaming in the sun, and it feels, I mean, entirely permanent.
Yeah.
Like it's unshakable. But you don't see the foundation.
Right, the stuff underground.
Exactly. You don't see the centuries of engineering or, the failed blueprints or the raw materials that had to be literally dug out of the dirt just to make it stand up against the wind.
Which is kind of dangerous, honestly, because if you don't understand that foundation, you don't really understand how the building survives a hurricane. Or, well, more importantly, how to fix it when it starts to crack.
Yeah, that's such a good point. And today we are doing a deep dive into the ultimate skyscraper, which is human rights law.
Yes, we are.
So we got a message along with this just massive PDF of a textbook, and the request was super clear. They said, I need you to create an explanatory guide that covers all the topics and case laws from this PDF. Make sure you don't miss any. This is going to be used by teachers and students for exam preparation.
So to the student or teacher listening to this right now, we hear you.
We do. We have your syllabus right in front of us. But, we are not just going to read you a table of contents or machine gun a list of dates at you.
No, because rote memorization will only get you so far on a complex exam, you know?
Right.
The secret to actually mastering this material and, being able to argue it in a test essay is understanding the underlying logic, the actual mechanism.
Yeah, the why and the how.
Exactly. If you know why a judge ruled a certain way or how a specific historical trauma, forced a new law into existence, the names and dates will just naturally lock into place in your memory.
Okay, let's unpack this. We have a mountain of material to get through today, from ancient philosophy all the way down to modern Indian Supreme Court rulings.
It's a lot.
It is. So let's start at the absolute bedrock, because before anyone can argue about international treaties or United Nations covenants, we have to figure out why we even believe human beings have rights to begin with.
Right, the origin.
Yeah, where does this concept actually come from? Because reading this textbook, it seems like humanity spent thousands of years basically treating people as property before this idea really took hold.
It's true that the modern framework of human rights is relatively young, mostly post-World War II. But the philosophical soil it grew from is ancient. We have to look back to ancient Greece right around the 5th century BC. Greek philosophers started grappling with this idea that there is a set of laws established by the gods, or by nature itself, that sits, higher than any law made by a king or a local community.
So if the local king passes a terrible law, the philosophers could just point to the sky and say, the universe disagrees with you.
Basically, yeah.
But exactly how did they apply that practically, though? It sounds a bit abstract for an actual legal system.
Oh, it was abstract. But the Romans took that Greek philosophy and turned it into actual jurisprudence.
Oh.
You had Cicero, the great Roman statesman and jurist, who wrote extensively about this eternal, immutable law. Because, the Romans had to manage a massive empire with dozens of different cultures.
Right, lots of different local customs.
Exactly. So they made a highly practical legal distinction for their courts. They had the jus civil, which was the civil law applicable only to Roman citizens.
Okay.
But then they recognized the jus gentium, the law of nations, which were principles common to all the different peoples they encountered.
Like basic rules of trade or property that everyone seemed to just agree on, regardless of their local god.
Yes, and overseeing it all was this concept of just natural law derived from human reason.
Got it.
They believed that because all humans have reason, there are certain universal rules of justice. And we shouldn't just look at Europe here either. We see very similar conceptual frameworks in ancient Indian philosophy.
Like the concept of dharma.
Right. Exactly. Dharma wasn't just about religious duty. It was this deeply ingrained system aiming to strike a just balance in the social and cosmic order, dictating how a ruler must treat their subjects.
Okay, but then the Roman Empire falls, and we hit the Middle Ages.
Yeah.
And the textbook brings up St. Thomas Aquinas here.
Yes, a major figure.
Which is funny because the Middle Ages usually get characterized as this, dark period of absolute feudal subjugation.
Right.
But Aquinas seems to be doing some heavy lifting for legal theory.
He really was. Aquinas was pivotal because he managed to merge the classical Greek and Roman ideas of natural law with Christian theology.
Oh, interesting.
Yeah, he argued that natural law is humanity's participation in the eternal divine law. But here is the massive breakthrough for human rights. Aquinas argued that the state, the earthly king, is subject to this higher divine law.
Which means the king is not God.
Precisely the point. And because the king is not God, if the king passes a law that violates natural law, Aquinas basically said it's not actually a law.
It's a fake law.
Right, it's a perversion of law. And this laid the early philosophical groundwork for the right to revolt against a tyrant. If the ruler breaks the higher law, the people are justified in pushing back.
And we see that pushback crystallize into actual physical documents eventually. When I was looking through the textbook's history section, I kind of started thinking of these early English charters as the beta versions of modern human rights.
Oh, that's a good way to frame it.
Yeah, like you have the Magna Carta in 1215. The barons literally forced King John to sign a document saying he couldn't just imprison people without lawful judgment, and he couldn't levy taxes without common counsel.
The Magna Carta is a perfect example of a local political dispute accidentally birthing a universal legal principle. It established that the sovereign is not above the law.
Right.
Then, fast forward to 1628 with the Petition of Right, which further limited the English monarch's power, specifically against arbitrary arrest and martial law in times of peace. And then the English Bill of Rights in 1689, which established parliamentary sovereignty and protections against cruel and unusual punishment.
But those were still very focused on English subjects dealing with English kings.
No.
So how do we get from rights of Englishmen to, like, rights of all humans?
That happens in the 17th and 18th centuries with the explosion of social contract theory. Thinkers like Hugo Grotius and Imre de Vattel, and later John Locke and Jean-Jacques Rousseau.
The heavy hitters.
Yeah. They hypothesized a state of nature before governments even existed. And they argued that in this natural state, humans already possessed inherent rights like life, liberty, and property.
I see. So the logic flips entirely. You don't get your rights from the government. You already have them.
Exactly.
And you only agree to create a government to help protect those pre-existing rights. So you bring your rights to the government.
That is the absolute core of the social contract. You surrender some freedoms, like, the freedom to enforce the law yourself, in exchange for the state protecting your fundamental rights. And if the state fails to protect them or actively violates them, the contract is broken. This was the exact philosophical justification used to ignite the American and French revolutions.
Which gives us the blockbuster documents of the late 18th century. The Virginia Declaration of Rights in 1776, Thomas Jefferson writing the American Declaration of Independence claiming unalienable rights, and of course the French Declaration of the Rights of Man and of the Citizen in 1789.
Those documents fundamentally shifted the global narrative. They enshrined this idea that the primary purpose of any legitimate government is the preservation of human rights.
Right.
But, and this is massive, but for your exam, this was still mostly an internal domestic affair.
Right.
Throughout the 19th and early 20th centuries, traditional international law had a massive blind spot.
State sovereignty.
Absolute state sovereignty. Under classic international law, the only subjects of international law was states. Individuals had no standing whatsoever. Yeah. How a sovereign state treated its own citizens inside its own borders was entirely its own business. If a king wanted to oppress his own people, other countries had zero legal right to intervene.
That seems like a massive loophole. Like, if you happen to be born on the wrong side of a border drawn on a map, you have absolutely zero recourse if your government turns on you.
It was a catastrophic loophole. But in the 19th century, we started seeing tiny cracks in that wall of absolute sovereignty.
Like what?
Well, we saw the emergence of the doctrine of humanitarian intervention. Major powers started intervening when other states committed shocking atrocities against their own people.
Oh, I see.
For example, European powers intervened on behalf of the Greeks in 1827 during their war for independence against the Ottoman Empire, and later interventions occurred to protect Christian minorities in the Levant.
But those interventions were often, completely entangled with imperialism and geopolitical self-interest. Right. It wasn't exactly a pure, impartial human rights crusade.
Oh, very true. It was highly selective. But legally, it established a precedent that sovereignty was not an impenetrable shield against mass atrocities.
Okay.
Then we get the horror of World War I. Millions dead, empires shattered. The global community realizes they need an organized way to prevent this from happening again, which leads to the creation of the League of Nations in 1919.
Looking at the syllabus, though, the League of Nations didn't actually have a universal human rights mandate, did it? It feels like it was mostly focused on just preventing states from shooting at each other.
You're right. The Covenant of the League of Nations did not explicitly mention universal human rights.
Huh.
However, it did create the mandate system for former colonies, demanding the well-being and development of those peoples.
Yeah.
It also established minority treaties to protect linguistic, racial, and religious minorities in newly formed Eastern European states. So it was a fragmented approach, but it was a step toward internationalizing the protection of individuals.
The textbook also highlights the International Labor Organization, the ILO, which was created at the exact same time as the League of Nations. Why is a labor organization so central to human rights history?
Because the founders of the ILO recognized a profound truth, which is that you cannot have universal and lasting peace without social justice.
Right.
The Industrial Revolution had created brutal working conditions. The ILO was established to set international standards for workers' rights, regulating working hours, protecting women and children in factories, and ensuring a living wage.
So it's basically the foundation of economic rights.
Exactly. This is crucial for your exam because the ILO is the pioneer in recognizing that economic and social rights are just as vital as civil and political rights.
Okay, so we've tracked the historical evolution. We have the philosophy, we have the early domestic charters, and we have the tentative international steps, the League and the ILO.
Yeah.
All of this basically sets the stage for the massive paradigm shift after World War II. But before we get to the United Nations, the textbook demands that we actually define what a human right is. And it provides 4 distinct definitions from legal scholars that students really need to be able to articulate.
Definitions in law are never just semantics, right? They dictate how laws are enforced. So let's look at the 4 scholars. First, Richard Wasserstrom.
Okay.
He defines human rights practically. He says they are the minimal things needed for a person to develop their capabilities and live a life as a human being. It's heavily focused on human potential.
Then we have Joel Feinberg, who takes a more philosophical approach. He calls them moral rights held equally by all human beings, unconditionally and unalterably.
The key word for Feinberg is unalterably. You cannot lose them.
Got it.
Third is Maurice Cranston. He defines human rights as universal moral rights that all people everywhere ought to have, and he adds a consequence. Depriving someone of these rights is a grave affront to justice. It's not just a deprivation, it's a moral crime.
And finally, the prominent Indian constitutional scholar, D.D. Basu. He defines them as those minimal rights which every individual must have against the state by virtue of being a member of the human family.
Notice what Basu does there. He specifically highlights the relationship against the state.
That's interesting.
He recognizes that the state is usually the entity with the power to violate these rights, so the definition itself must include a defense mechanism against state power.
I want to push back on this whole concept, though. I mean, we have all these definitions asserting that human rights are universal, inborn, and unalterable. But if that's an objective truth, why does the textbook then list 5 completely different jurisprudential theories arguing about where these rights actually come from?
It's a fair question.
If they're so universal, shouldn't we all agree on their source by now?
That is the perennial debate in legal philosophy, and it's heavily tested. You need to understand the underlying friction between these 5 theories. We've already discussed the first, the theory of natural rights.
Right.
This argues that rights are inherent, absolute, and pre-civil. You have them simply because you exist.
But the obvious critique of the natural rights theory is, well, who enforces it? I mean, if rights are just inborn and handed down by the universe or by nature, how do you actually protect them? The universe doesn't have a police force or a court system.
Exactly. And that frustration led to the second theory, the legal theory of rights. Thinkers like Jeremy Bentham and John Austin argued that natural rights are, in their words, nonsense upon stilts.
Wow. Okay.
Yeah, they argued that rights do not exist in some abstract ether. A right only exists if it is created, codified, and enforced by the state. Without a legal system to protect it, a right is just a wish.
I understand the practical logic, but that sounds incredibly dangerous. If the state creates the rights, doesn't that inherently mean the state can just legally revoke them whenever it's convenient? Like, you're leaving the citizens entirely at the mercy of whatever lawmakers happen to be in power. If a fascist government gets elected and passes a law stripping a minority of their citizenship, under the legal theory, that minority has no rights left to claim, right?
That is the exact nightmare scenario. And history has shown us that states are more than willing to legally strip rights away, which is why we turn to the third theory, heavily associated with the philosopher Ronald Dworkin, which is the anti-utilitarian theory.
Utilitarianism is the idea that society should do whatever brings the greatest happiness to the greatest number of people, right?
Yeah.
The classic trolley problem applied to macroeconomics and social policy.
Right. But Dworkin looked at utilitarianism and realized it's a massive threat to minorities. Let's say a society realizes that enslaving 10% of the population will make the economy boom and make the other 90% incredibly happy.
Horrifying.
A pure utilitarian might say, mathematically, the total happiness is increased, so it's a good policy. But Dworkin argues that human rights exist specifically to function as trumps against majority happiness.
Oh, I love that visualization. A human right is a trump card you slam on the table when the majority tries to crush you.
Yeah.
Like, it doesn't matter if violating my right to free speech would make the rest of the country ecstatic. My right trumps your collective happiness. It's a protective shield against the tyranny of the majority.
Perfectly stated. Now, the fourth is the legal realist theory. The realists look at society and say, let's stop talking about abstract origins and look at how things actually work on the ground.
Pragmatic.
Very. They view rights not as static historical concepts, but as an ongoing, messy process of claims and demands. A right is whatever the prevailing moral values of a society have successfully fought to establish and protect at any given moment. It's dynamic.
So under legal realism, the right to privacy regarding digital data didn't exist 100 years ago, but because society is actively fighting for it and making demands today, it is becoming a recognized right. It evolves with human behavior.
Spot on.
Okay, what's the fifth theory?
The Marxist theory of rights. Karl Marx fundamentally critiqued the Western capitalist concept of natural rights. He argued that the bourgeois declarations of rights, like the right to property, were designed specifically to protect the interests of the dominant property-owning class while keeping the working class exploited.
Because if you give a starving factory worker the freedom of speech, but not enough money to buy food, that freedom is basically useless to them.
Precisely. Marxists argue that true rights and true freedom can only exist in a classless society where the means of production are collectively owned. Therefore, Marxist theory focuses almost entirely on social and economic rights: the right to work, the right to health, the right to education.
So the state isn't the enemy there.
No, the state isn't something to be protected against. The state is the mechanism that should aggressively distribute resources to ensure equality. And as we'll see, this ideological split heavily influenced the United Nations during the Cold War.
Before we cross into the United Nations era, let's quickly tie a bow on the philosophical section by reviewing how the textbook classifies these rights. We have natural rights, which are inherent from birth; moral rights, which are based on a society's ethical code of fairness and justice, even if they aren't written in law;
Right.
fundamental rights, which are the core constitutional guarantees, like the right to life, that are practically untouchable; and legal rights, which are ordinary rights granted by everyday statutes.
And for your exam essays, you must be comfortable using the generational terminology. Civil and political rights, like the right to vote, freedom of speech, freedom from torture, are often called first-generation rights. They generally require the state to step back and not interfere.
Right.
Economic, social, and cultural rights, like the right to housing, healthcare, and education, are known as second-generation rights. These usually require the state to actively step in and spend resources.
So we have all these competing theories and classifications. But after the Holocaust and the absolute devastation of World War II, the world needed a practical document, not just a philosophical debate in a university hall. They needed to actually put pen to paper and create a baseline for human survival. How do they actually do it?
They created the United Nations in 1945. The UN Charter explicitly stated that one of its main purposes was promoting and encouraging respect for human rights. But the Charter didn't actually list what those rights were.
Right, they needed specifics.
They needed a catalog. So under the leadership of Eleanor Roosevelt, the UN Commission on Human Rights drafted the Universal Declaration of Human Rights, the UDHR, which was adopted by the General Assembly on December 10, 1948.
The UDHR is the absolute cornerstone of modern international law. The textbook outlines its structure, which consists of 30 articles. And to memorize this for the exam, it helps to break it into 4 blocks.
Let's walk through them. Articles 1 and 2 are general. They lay out the philosophical foundation. All human beings are born free and equal in dignity and rights, and everyone is entitled to these rights without discrimination of any kind: race, color, sex, religion. It's the baseline assumption.
Then we get the massive block of first-generation rights. Articles 3 through 21 cover the civil and political rights. This is the right to life, liberty, and security of person; freedom from slavery and torture;
Very important ones.
the right to a fair and public trial; freedom of thought, conscience, religion, and expression; and the right to participate in your government.
Then the Declaration pivots. Articles 22 through 27 cover the second-generation rights, the economic, social, and cultural rights. This includes the right to Social Security, the right to work for fair wages, the right to rest and leisure, the right to education, and the right to a standard of living adequate for health and well-being.
Which was huge, right?
This inclusion was revolutionary. It meant the UN was acknowledging that civil liberties mean nothing if you are starving.
Finally, Articles 28 to 30 are the concluding articles. They provide the framework for how these rights exist in society, stating that everyone has duties to their community, and crucially, Article 30 states that nothing in the Declaration can be used by a state or person to destroy any of the rights within it. It's a self-preservation clause.
Exactly.
Now, here is a massive debate that the textbook spends a lot of time on, and it's guaranteed to be on the exam. Is the UDHR actually binding law? Because it's called a declaration, not a treaty or a covenant.
That is the million-dollar question in international law. Originally, the prevailing view in 1948 was that it was absolutely non-binding. It was adopted as a resolution by the UN General Assembly.
Yeah.
General Assembly resolutions possess strong moral and political force, but they do not create binding legal obligations on member states the way a ratified treaty does. It was meant to be a common standard of achievement, kind of like an aspirational wish list.
But wait, if it's just a wish list, why do international courts constantly cite it when they condemn countries for human rights abuses?
Because of the second view, which is the overwhelmingly accepted view today. Over decades of consistent reliance by states, by international bodies, by domestic constitutions copying its text, the UDHR has evolved. It is now widely considered to be customary international law.
Explain how that transformation happens. I mean, how does a piece of paper magically turn into binding law without countries signing a new treaty?
Customary international law is created when two elements are present: widespread and consistent state practice, and opinio juris, which is the belief by states that this practice is legally required, not just a nice thing to do.
Oh, I see.
Because countries have spent over 70 years treating the core principles of the UDHR as legally binding, condemning each other for violating it, and incorporating it into their own laws, international courts now view those core principles as binding customary law.
And the syllabus lists several heavy-hitting case laws where global courts have used the UDHR to prove exactly this. Let's look at the International Court of Justice, the ICJ.
Yes, the ICJ invoked the UDHR in the U.S. diplomatic staff in Tehran case. When American hostages were taken in Iran, the ICJ ruled that wrongfully depriving human beings of their freedom and keeping them in conditions of hardship was incompatible with the principles of the UN Charter and the fundamental principles enunciated in the Universal Declaration of Human Rights.
Wow.
They didn't just call it a moral failing, they called it a legal violation based on the UDHR.
The ICJ also referenced it in the asylum case and the Corfu Channel case. And it's not just the ICJ. The International Criminal Court, the ICC, heavily relied on human rights norms in the Omar al-Bashir case, dealing with genocide and war crimes in Darfur.
Right.
But the most fascinating example to me is how the UDHR infiltrates domestic courts. Look at the U.S. Circuit Court of Appeals case, Filartiga v. Pina Irala.
Oh, Filartiga is a landmark case. A young man from Paraguay was tortured and murdered in Paraguay by a Paraguayan police official. The victim's family eventually found the official living in the United States and sued him in U.S. federal court under a very old statute called the Alien Tort Statute. The massive legal hurdle was, did torture violate the law of nations?
And the U.S. court didn't look at a specific treaty Paraguay had signed. They looked at the UDHR. They ruled that the prohibition of torture has become part of customary international law, as evidenced by the Universal Declaration of Human Rights.
It's incredible.
A domestic U.S. judge used a UN declaration to punish a foreign official for a crime committed in South America. That is the power of customary international law.
But despite the UDHR evolving into custom, the UN wanted hard, indisputable, signed legal obligations. They wanted a treaty. The original plan was to draft a single treaty encompassing all the rights in the UDHR. But the politics of the Cold War made that impossible.
Because of the ideological split we talked about earlier.
Right. The capitalist West prioritized civil and political rights, while the communist bloc prioritized economic and social rights.
So they split the baby. In 1966, they adopted two separate treaties: the International Covenant on Civil and Political Rights, the ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, the ICCR. I was trying to conceptualize how these two covenants operate differently, and I kind of think of it like managing a household. The ICCPR, the civil and political rights, are the immediate, non-negotiable rules of the house. No hitting, No locking people in the basement. Everyone gets a say in what's for dinner.
I like that.
You don't need a massive bank account to enforce no hitting. It's an immediate negative obligation. The state just has to refrain from doing evil.
And the ICSCR?
The ICSCR, the Economic and Social Rights, is like the household budget saving up for a better life. You can't just mandate that a struggling family instantly provides a mansion, top-tier private schooling, and a personal doctor for everyone in the house. You have to progressively realize those goals based on the available resources you bring in.
That is a highly effective way to frame it for an exam essay. For the ICCPR, Article 2 demands that states must respect and ensure these rights immediately upon ratification. There is no waiting period.
Okay.
Now, an incredibly important nuance for the ICCPR is Article 4, which deals with derogation.
Derogation meaning the state's ability to temporarily suspend rights.
Exactly. Article 4 acknowledges reality. During a massive public emergency that threatens the very life of the nation, like an invasion or catastrophic natural disaster, states are allowed to temporarily suspend certain civil and political rights to manage the crisis. They can impose curfews or restrict freedom of assembly.
But, and this is a huge but that examiners love to test, a state cannot suspend everything. There is a hard floor.
Yes. You must memorize the non-derogable rights. No matter how severe the emergency, a state can never suspend the right to life. They can never suspend freedom from torture or cruel punishment. Freedom from slavery is non-derogable, and protection against ex post facto laws is non-derogable, meaning the state cannot suddenly pass a law today making something a crime and then execute you for doing it yesterday when it was legal.
To monitor all this, the ICCPR created the Human Rights Committee. States have to submit regular reports on how they are implementing the rights. And if a state signs the first optional protocol, individuals can actually bring complaints directly to the committee against their own government.
All right.
Now let's look closer at the household budget, the ICESCR. The wording of its primary obligation is very different from the ICCPR.
What's fascinating here is the operative mechanism in Article 2 of the ICSCR, the concept of progressive realization. The treaty acknowledges that not all countries have the GDP to instantly guarantee adequate housing, top-tier healthcare, and free higher education for every single citizen.
Right.
The obligation on the state is to take steps to the maximum of its available resources to progressively achieve the full realization of these rights.
Okay, my skeptical brain is flashing red lights again. If I am a corrupt dictator, progressive realization sounds like the ultimate get-out-of-jail-free card. I can just say, sorry, we don't have the resources right now. We'll get you housing eventually, maybe in 50 years. How does international law prevent states from using this as an excuse to do absolutely nothing?
It's a totally valid concern. The Committee on Economic, Social, and Cultural Rights has issued general comments to close that loophole. They clarified that progressive realization does not mean a state can just stall.
Okay.
States have a core minimum obligation to ensure the satisfaction of, at the very least, minimum essential levels of each of the rights. For example, a state must provide essential foodstuffs, basic shelter, and basic health care. Furthermore, states must move as expeditiously and effectively as possible. Any deliberately retrogressive measures, like a state destroying existing public housing without replacing it, are heavily scrutinized.
And there is one aspect of the ICSCR that is not subject to progressive realization, right?
Yes, the obligation of non-discrimination. A state cannot say, we are progressively realizing the right to education. So for the next 10 years, only boys can go to school while we save money. The guarantee that rights will be exercised without discrimination based on race, sex, or religion is of immediate effect.
Let's ground this in reality with the exam case laws. How do courts actually enforce socioeconomic rights, which seem so tied up in government budgets? Let's look at European Roma Rights Center v. Portugal.
In this case, the European Committee of Social Rights looked at the living conditions of Roma communities in Portugal. They found families living in segregated, precarious settlements with no access to basic water, electricity, or sanitation.
Wow.
The state argued they were trying to improve housing over time, but the committee found a violation. They ruled that the state failed to take sufficient concrete steps to improve the housing conditions of this specific vulnerable group, and that the segregation constituted immediate illegal discrimination.
Then there is the Inter-American Court case, Girls Yain and Bosico v. Dominican Republic. This case is heartbreaking, but legally fascinating regarding how rights intersect. Two girls of Haitian descent were born in the Dominican Republic, but the state refused to issue them birth certificates, rendering them effectively stateless.
Right.
Because they had no identity documents, They were blocked from attending day school.
The state was essentially trying to use bureaucratic red tape to deny a fundamental right. The Inter-American Court ruled that the state violated the girl's right to a nationality. But more importantly, for our discussion of socioeconomic rights, the court found a violation of the right to education. They ruled that the immediate obligation of non-discrimination means a state cannot use a child's lack of documentation, especially documentation the state itself wrongfully withheld, to deny them access to basic education.
And finally, a massive case regarding communal property and cultural rights. Kichwa indigenous people of Soriaku v. Ecuador.
The facts here are striking. The Ecuadorian state granted a permit to a private oil company to explore for oil on the ancestral territory of the Soriaku people. The company moved in with armed guards, cut down forests, and even buried highly explosive materials on the land. Crucially, the state did all this without consulting the indigenous community.
Which goes back to our discussion of property rights.
Yeah.
The indigenous community didn't necessarily have a Western-style real estate deed to this massive jungle.
Right, but the Inter-American Court recognized that indigenous property rights are not just economic, they are cultural and spiritual. The court ruled that the state violated the community's right to communal property and their right to cultural identity.
Right.
The land is inextricably linked to their survival as a distinct people. The state has an absolute obligation to obtain free, prior, and informed consent before authorizing projects that affect indigenous territories.
So we've seen these grand, sweeping mandates from the United Nations. But the UN is headquartered in New York and Geneva. It's distant, and cultures vary wildly across the globe. How do these global ideals get customized and enforced on a regional level? Let's look at the regional human rights systems, starting with Europe, which the textbook notes is the most legally developed system.
Europe had a massive head start. Just a few years after the UDHR, the Council of Europe adopted the European Convention on Human Rights, the ECHR, in 1950. Originally, the system had a commission to filter complaints and a court to hear them.
Okay.
But as the caseload exploded, they passed Protocol 11, which is a key term for your exam. Protocol 11 abolished the commission and streamlined the entire system into a single, full-time European Court of Human Rights based in Strasbourg, France.
This court is incredibly powerful. Any individual in Europe who feels their rights have been violated by their state can petition the Strasbourg court directly, provided they have exhausted all the legal remedies in their own country first. But the ECHR is heavily focused on civil and political rights. To handle the economic side, Europe adopted the European Social Charter in 1961. And the textbook highlights its unique dual-layer structure.
The Social Charter is a brilliant piece of diplomatic compromise. Part 1 of the Charter contains a list of broad, aspirational rights, like the right to work in safe conditions, the right to collective bargaining, and the right to Social Security. States accept these as general policy aims.
And Part 2?
Part 2 contains the hard, binding obligations. States ratifying the Charter must agree to be legally bound by a certain minimum number of articles from Part 2. It allows states to opt in based on their economic readiness while still pushing them forward.
Let's look at how civil and economic rights collide in domestic European courts. There is a fascinating Swiss case from 1995, Vivi Einwohnergemeinde X. 3 Czech nationals were living illegally in Switzerland. They had committed criminal offenses, so the Swiss authorities expelled them.
But the expulsion failed. They couldn't get back into the Czech Republic, so they returned to Switzerland. Now they are in Switzerland, entirely undocumented, with no right to work, no money, and no food. They applied to the local Swiss municipality for basic social welfare just to survive, and the municipality said, no, you are illegal immigrants and criminals.
Which sounds, legally speaking, like a solid argument for the municipality. Why should the state pay to feed undocumented criminals?
But the Swiss federal court looked at the absolute rock bottom of human existence and ruled in favor of the individuals.
Really?
Yeah, they held that even without a specific statute granting welfare to illegal immigrants, the Swiss Constitution contains an implied, unwritten fundamental right to a basic level of subsistence. The court reasoned that the state guarantees the right to life and human dignity. If you deny a human being the minimal food and shelter necessary to prevent them from freezing or starving to death in the streets, you are entirely destroying their human dignity. You cannot exercise any civil or political rights if you are dead.
It's a profound recognition that economic survival is the prerequisite for all other rights. Now, let's shift to the Inter-American system, governed by the Organization of American States, or OAS. This system rests on 2 pillars created by the American Convention on Human Rights in 1969.
The first pillar is the Inter-American Commission on Human Rights, based in Washington, D.C. They act as the investigators and mediators. They receive individual petitions, conduct fact-finding on-site visits to countries in crisis, and issue recommendations to states.
Right.
If a state simply ignores the Commission's recommendations, the Commission can refer the case to the second pillar, the Inter-American Court of Human Rights, based in Costa Rica.
And the Costa Rica court has delivered some incredibly bold judgments, especially regarding marginalized groups. The syllabus highlights Atala Rifo and Daughters v. Chile.
Karen Atala Riffer was a Chilean judge and a mother of 3. After she came out as a lesbian and began living with her partner, her ex-husband sued for custody of their daughters, arguing that growing up in a same-sex household would damage the children's development. The Chilean Supreme Court agreed and stripped her of custody solely based on her sexual orientation.
But she took the case to the Inter-American Court, and in 2012, they delivered a landmark ruling.
They ruled decisively against Chile. The court established that sexual orientation and gender identity are categories strictly protected against discrimination under the American Convention. They stated that a person's sexual orientation cannot be used as a rationale to presume they are unfit parents, and that traditional societal prejudices cannot be elevated into legal reasoning.
We also absolutely must discuss the Velázquez-Rodriguez v. Honduras case from the 1980s. This deals with the terrifying phenomenon of enforced disappearances.
An enforced disappearance is perhaps the most insidious human rights violation because it is designed to erase the evidence. State agents, police, or military abduct a person. Then, the state completely denies that they have the person or refuses to give any information about their fate, placing the victim entirely outside the protection of the law. Manfredo Velázquez was a university student kidnapped by heavily armed men in civilian clothes linked to the Honduran military.
The terrifying part is that the family goes to the police, and the police say, "We don't know where he is, maybe he ran away." How does an international court prove the state did it when the state controls all the evidence?
That was the brilliance of the Velázquez-Rodriguez judgment. The Inter-American Court recognized that requiring strict, direct evidence of a kidnapping when the government is actively hiding it is impossible.
Right.
So the court allowed circumstantial evidence and logical inference. They ruled that if a pattern of disappearances exists in a country and a specific case fits that pattern, the burden of proof shifts to the state to prove they didn't do it. The court found Honduras responsible, establishing a monumental precedent for state accountability.
Okay, let's look at the third regional system, the African system. The primary instrument here is the African Charter on Human People's Rights, also known as the Banjul Charter, adopted in 1981. This charter is totally unique compared to the European or American systems.
It is unique because it was drafted to reflect African historical realities and cultural philosophy. The most striking difference is found in Article 29, which explicitly lists the duties of the individual.
Interesting.
In Western legal thought, rights are mostly about the individual against the state. The African Charter emphasizes community. It states individuals have duties toward their family, society, the state, and other legally recognized communities.
It also protects people's rights, not just individual rights, but collective rights.
Exactly. These are third-generation solidarity rights. The Charter recognizes the right of peoples to self-determination, the right to economic, social, and cultural development, and the right to a generally satisfactory environment. This was a direct response to the legacy of colonialism, asserting that an entire colonized people have a collective right to control their own wealth and resources.
And we also need to note the Maputo Protocol of 2003, which is a supplementary protocol specifically focusing on women's rights in Africa. It is remarkably progressive. For example, it explicitly guarantees the right to a medical abortion in cases of sexual assault, rape, incest, or when the pregnancy endangers the mother's life for health.
It's a very strong document.
Let's look at a couple of key cases from the African Commission. First, Civil Liberties Organization v. Nigeria.
During the 1990s, Nigeria was under a military dictatorship. The military government started passing ouster clauses decrees, explicitly stating that no domestic court in Nigeria had the jurisdiction to question any action taken by the military government. They were trying to legally immunize themselves.
But the African Commission stepped in and ruled that an internal decree cannot override international obligations. A state cannot sign the African Charter and then pass a domestic law saying the charter doesn't apply. International human rights standards must prevail.
And in Jawara v. the Gambia, the Commission addressed a very practical procedural hurdle. We mentioned earlier that before you go to an international court, you must exhaust domestic remedies. You have to try to get justice in your own country's courts first. Former President Jawara filed a complaint after a military coup overthrew his government.
But if there is a military coup, the courts are likely compromised or suspended.
Which is exactly what the commission ruled. They clarified exceptions to the exhaustion rule. If domestic remedies are practically unavailable, hopelessly ineffective, or if pursuing them would be dangerously protracted, you don't have to wait. The victim can go straight to the international body.
So we've seen these massive global and regional frameworks. But if I'm a citizen in India, a treaty signed in Geneva or a ruling from a commission in Banjul doesn't actually help me unless my own local police and judges actually enforce it.
Yeah.
How did India translate those global ideals into ground-level reality?
If we connect this to the bigger picture, this brings us to the Indian framework. The timing here is critical. The Indian Constituent Assembly was drafting the Constitution right as the UN was adopting the UDHR in the late 1940s.
Oh, wow.
The drafters in India were looking at a nation scarred by centuries of colonial exploitation, the horrific violence of partition, and deep, entrenched social inequalities like the caste system. They needed a document that didn't just organize a government, but actively reformed a society.
So they looked at the UDHR and essentially mapped it directly onto the Indian Constitution, which came into force in 1950. But they split it into two parts, mirroring the split that would happen at the UN years later.
Yes. The civil and political rights, the immediate non-negotiable rules, were placed in Part 3 of the Constitution as fundamental rights. These are deeply powerful justiciable rights.
Like what?
Article 14 guarantees equality before the law. Article 19 guarantees fundamental freedoms like speech and assembly. And the absolute core is Article 21, guaranteeing the right to life and personal liberty. If the state violates these, a citizen can go directly to the Supreme Court or high courts for a remedy.
But then they took the economic, social, and cultural rights, the right to work, to education, to a living wage, and put them in Part 4 as the directive principles of state policy.
And crucially, the Constitution explicitly states that the directive principles are not enforceable by any court. They are fundamental in the governance of the country, and it is the duty of the state to apply them in making laws, but a citizen couldn't sue the government in 1950 for not providing them a job. The new Indian Republic simply did not have the financial resources to guarantee those rights immediately. They were aspirational goals for progressive realization.
Fast forward a few decades. Having constitutional rights is great, but in the early 1990s, India was facing intense international criticism over alleged human rights violations in conflict zones like Kashmir and Punjab. There was pressure to create an independent body to investigate these claims. This led to the enactment of the Protection of Human Rights Act, the PHRA, in 1993.
The PHRA was designed to create specialized, independent institutions for the better protection of human rights. It established the National Human Rights Commission, the NHRC, at the federal level, and allowed states to create their own state human rights commissions, or SHRCs.
For the exam, students need to know the specific powers of the NHRC outlined in Section 12 of the Act.
The NHRC has broad investigative powers. Most importantly, they can inquire into human rights violations suo moto.
Meaning, on their own initiative. Why is that specific power so important?
Because victims of severe human rights violations, like police torture or bonded labor, are often too terrified, marginalized, or impoverished to file a formal complaint. Suo moto power allows the NHRC to read a newspaper report about an atrocity and immediately launch an investigation without waiting for the victim to step forward.
That's a huge shift in power.
Furthermore, they can intervene in ongoing court proceedings involving human rights with the court's approval. They have the mandate to visit jails and detention centers to review the living conditions of inmates. They review domestic laws and international treaties to recommend improvements, and they actively promote human rights literacy. And when they conduct these inquiries, they are armed with the powers of a civil court. They can summon witnesses, demand the production of documents, and receive evidence on affidavits.
Let's look at the human impact of the NHRC with two critical cases. First, the Charanjit Singh case.
Charanjit Singh was a mentally challenged individual who was arrested and held as an under-trial prisoner. His case languished in the system for an astonishing 16 years without a conclusion.
16 years.
Yes. The NHRC discovered this horrific delay and intervened directly. They filed an application in the Delhi High Court arguing that this massive delay fundamentally violated his right to a speedy trial under Article 21. The High Court agreed, quashed the trial, and ordered his immediate release.
It's a stark reminder that a slow legal system can be a form of torture. Then there's the Chakma refugees case.
The Chakmas were refugees who fled religious persecution in East Pakistan, which is now Bangladesh, and settled in the Indian state of Arunachal Pradesh. Decades later, local political groups started issuing threats, demanding the refugees leave the state, and the local government essentially stood by and let the harassment happen, refusing to provide adequate police protection.
The local government's logic was likely, well, they aren't Indian citizens, so we don't owe them fundamental rights.
Exactly. But the NHRC took the matter straight to the Supreme Court of India, and the Supreme Court delivered a monumental ruling. They held that while certain rights, like the right to vote or travel freely, are restricted to citizens, the core guarantee of Article 21, that no person shall be deprived of his life or personal liberty, applies to every single person on Indian soil, citizen or alien. The court ordered the state to actively protect the lives and property of the Chakma refugees.
Now, the PHRA didn't just stop at creating commissions. Section 30 of the Act envisioned a grassroots approach, establishing human rights courts in every district across the country for the speedy trial of human rights offenses.
The mechanism was that the state government, with the concurrence of the Chief Justice of the local high court, could simply designate an existing court of session as a human rights court, and they would appoint a special public prosecutor with at least 7 years of experience to handle the cases.
It sounds great in theory, a fast-track court for human rights, but practically it caused massive confusion. The Act didn't actually define what a human rights offense was. Does a regular murder count? Does a landlord locking out a tenant count? The Madras High Court had to step in and clarify this in the Tamil Nadu Pazankudi Makal Sangam case.
The High Court laid down essential guidelines to stop the chaos. They clarified that human rights courts are not meant to try ordinary crimes committed by private individuals against each other. They are specifically meant to try offenses committed by instrumentalities of the state like police brutality, custodial torture, or illegal detention by public servants.
They also clarified the limits on compensation, right?
Yes. Because these designated human rights courts are ultimately criminal courts, courts of session, the High Court ruled they cannot grant massive civil damages. They are restricted to granting compensation only up to the limits allowed under Section 357 of the Criminal Procedure Code. They are fast-track criminal courts for state abuses, not civil tribunals for massive payouts.
So we have the Constitution, we have the NHRC, we have human rights courts. But what happens when the government drags its feet? When the text of the law is silent on a new, modern problem? This brings us to the beating heart of Indian human rights law, the courts in action and the era of judicial activism.
The Indian Supreme Court has arguably been one of the most proactive, inventive constitutional courts in the world over the last 50 years. Through the mechanism of public interest litigation, or PIL, they relaxed the strict rules of who could approach the court, allowing public-spirited citizens and NGOs to file cases on behalf of the poor and marginalized.
And the absolute engine of this judicial activism is one single sentence in the Constitution. Article 21. No person shall be deprived of his life or personal liberty except according to procedure established by law.
Right after the Constitution was adopted in 1950, the Supreme Court took a very literal, narrow view of Article 21. In the famous A.K. Gopalan case, they basically ruled that as long as the legislature passed a validly enacted law outlining a procedure for depriving someone of liberty, the court couldn't interfere. Even if the law was harsh or draconian, if it was passed by Parliament, it was valid.
But that philosophy was completely obliterated in the late 1970s with the landmark Maneka Gandhi case.
Maneka Gandhi's passport was impounded by the government in the public interest, and the statute didn't require the government to give her a reason or a hearing before doing it. She challenged this under Article 21.
Right.
The Supreme Court completely reversed its A.K. Gopalan stance. They ruled that the procedure established by law cannot be arbitrary, unfair, or unreasonable. The procedure itself must be just, fair, and reasonable.
That is a massive philosophical leap. The court saying it's not enough that Parliament passed a law. The law itself must conform to a higher standard of fairness. It's almost bringing a touch of natural law back into the constitutional framework.
It was a revolution. By demanding that the law be just, fair, and reasonable, the Supreme Court opened the floodgates. They began interpreting the word life in Article 21 to mean not just mere animal existence, but the right to live with human dignity. And anything that detracts from human dignity is a violation of Article 21.
This interpretation rapidly reformed the criminal justice system. Look at the Husainara Khatun case.
A newspaper published an expose revealing that thousands of under-trial prisoners, people who hadn't been convicted of anything yet, were languishing in miserable conditions in prisons across the state of Bihar. Many had been locked up waiting for trial for periods far longer than the maximum prison sentence they would have received even if they had been found guilty.
The Supreme Court read the right to a speedy trial directly into Article 21. They ruled that a justice system that keeps untried people in jail for a decade is fundamentally unfair and unreasonable. They ordered the release of tens of thousands of under trials.
Similarly, in Motoram v. State of MP, the court addressed the issue of bail. A poor laborer was granted bail, but the lower court demanded a massive surety amount that he could never possibly afford, effectively keeping him in jail indefinitely.
That's so unfair.
The Supreme Court struck this down, ruling that imposing exorbitant bail conditions on poor individuals is unreasonable and violates their liberty under Article 21.
And the court hasn't stopped at basic procedural rights. They have waded deep into the science of criminal investigation. Let's look at Selvi v. Karnataka.
The police were increasingly using techniques like narcoanalysis, so-called truth serum brain mapping, and polygraph tests on suspects without their consent. The government argued this was necessary for modern law enforcement.
But the Supreme Court drew a hard line protecting what we might call cognitive liberty.
The court ruled that forcing these tests on an individual violates the right against self-incrimination under Article 20, Section 3. But they went further, stating that it also constitutes a massive intrusion into personal liberty and mental privacy under Article 21. Your thoughts, your internal mental processes are your private domain. The state cannot chemically pry them open.
Let's shift from criminal justice to gender justice, an area where the court has been fiercely proactive. We have the Air India v. Yogesh Mirza case.
Air India, the state-owned airline, had blatantly discriminatory service regulations for female air hostesses. A woman was forced to retire if she got married within the first 4 years of her service, or if she reached the age of 35, or upon her first pregnancy, whichever came first.
Wow.
Male cabin crew faced no such absurd restrictions.
The Supreme Court struck these rules down with extreme prejudice. They declared the pregnancy rule unconstitutional, arbitrary, and an open insult to Indian womanhood, violating the right to equality under Article 14.
The judiciary has also actively upheld affirmative action mechanisms to ensure true substantive equality, rather than just formal equality on paper. In the massive Indrasani judgment, the court upheld the constitutional validity of reservations or quotas for backward classes in government jobs.
Right.
And specifically for gender, in Government of APV PB Vijayakumar, the court upheld rules providing specific reservations for women in public employment, noting that Article 15, Section 3 of the Constitution explicitly allows the state to make special provisions for women and children to overcome historical disadvantages.
But the most stunning example of judicial activism, where the court basically turned itself into a legislature, is the Vishaka v. State of Rajasthan case.
This is a cornerstone case. Banwari Devi, a social worker trying to stop child marriages in Rajasthan, was gang-raped. The subsequent trial and acquittals sparked outrage. Activists realized there was a massive legal vacuum. India had absolutely no domestic law dealing specifically with sexual harassment in the workplace. Women had no legal framework to demand a safe working environment.
So facing a total failure by Parliament to pass a law, what did the Supreme Court do? They didn't just tell the government to write a law. They looked at international law. They looked specifically at the CEDAW Convention, the UN Convention on Women's Rights, which India had ratified.
Because there was a void in domestic law, the Supreme Court ruled that international conventions can be read into fundamental rights to enlarge their meaning. They drew upon CEDAW to explicitly define sexual harassment and literally drafted a set of binding legal guidelines, the Vishaka Guidelines, mandating how every employer in the country must handle sexual harassment complaints. The court stated these guidelines would be the law of the land until Parliament formally enacted legislation, which didn't happen until 2013.
It's a breathtaking use of international law to force domestic progress. They reiterated this approach in the Apparel Export Promotion Council v. A.K. Chopra case, where they upheld the dismissal of a superior officer who tried to molest a female employee. The court explicitly cited international human rights norms to interpret the guarantee of gender equality under the Constitution. Now, what about those second-generation economic and social rights that were placed in Part 4, the Directive Principles? The Constitution said they weren't enforceable by courts, but the Supreme Court found a way around that too, didn't they?
Yes, the court began elevating directive principles into enforceable fundamental rights by reading them into Article 21. The right to education is a prime example. In the Mohini Jain case, dealing with exorbitant capitation fees charged by private medical colleges, the court declared that the right to life inherently includes the right to education. They reasoned that a citizen cannot possibly live with true human dignity without being educated.
This was slightly refined in the Uni Krishnan case. The court clarified that while the right to basic education up to the age of 14 is a fundamental right, the right to professional higher education is subject to the economic capacity of the state. But the jurisprudential momentum from these cases was unstoppable. It eventually forced Parliament to amend the Constitution, inserting Article 21A, explicitly making the right to education a fundamental right.
And when dealing with the realities of private education, the court had to balance competing rights. In monumental cases like TMA Pay Foundation and later unaided private schools of Delhi, the court recognized that private entities have a fundamental right to establish and administer educational institutions. However, they allowed the state to heavily regulate them to prevent the commercialization of education and ensure fairness in admissions, striking a balance between private enterprise and public welfare.
What about the right to health? That's another economic right that feels incredibly urgent.
The Supreme Court addressed the starkest, most urgent aspect of healthcare in Paramananda Katara v. Union of India. A man was gravely injured in a scooter accident. He was taken to a nearby private hospital, but the doctors refused to treat him, telling the people to take him to a government hospital far away because it was a medico-legal case involving an accident, and they didn't want to deal with police formalities. The man died during the delay.
So a man bleeds to death because doctors are afraid of police paperwork.
The Supreme Court issued a sweeping ruling. They held that it is the professional obligation of all doctors, whether in a government or private hospital, to extend immediate medical aid to preserve life. They ruled that doctors cannot refuse treatment or wait for police formalities to be completed. The preservation of human life is paramount under Article 21, and administrative procedures cannot be allowed to cause the death of an injured person.
Okay. Here is a philosophical knot that the Indian judiciary really struggled to untangle, and the jurisprudence gave everyone whiplash. The right to die. If you have a constitutionally guaranteed right to life under Article 21, does that inherently imply you have the right to end it?
It's a profoundly difficult question. Initially, in a case called P. Rathanam, a two-judge bench of the Supreme Court actually decriminalized the attempt to commit suicide. They used an analogy. The right to freedom of speech includes the right to remain silent. Therefore, the right to life includes the right not to live.
But that ruling didn't last long.
No, it was swiftly overturned 2 years later in the John Carr case. A 5-judge Constitution bench explicitly overruled Rathamam. They held that the right to life is a natural right, but suicide is an unnatural termination or extinction of life. Therefore, the right to die is inherently inconsistent with and mutually exclusive to the right to life.
So, no right to die. But decades later, medical technology forces the issue back into the courts. What do you do when a person is kept alive entirely by machines, with no hope of recovery? This leads to the tragic and legally monumental Aruna Shanbhag case.
Aruna Shanbhag was a nurse who was brutally sexually assaulted and choked with a dog chain in 1973. The attack cut off oxygen to her brain, leaving her in a persistent vegetative state for 42 years, cared for by the nurses at her hospital. A journalist filed a petition seeking permission to stop feeding her, arguing that her continued existence in that state was a violation of her dignity.
And while the court ultimately declined to withdraw life support for Aruna herself, deferring to the wishes of the nurses who cared for her, the legal ruling established a massive precedent.
It did. The Supreme Court distinguished between active euthanasia, administering a lethal injection, which remains illegal, and passive euthanasia, the withdrawal of life-prolonging medical treatment from a terminally ill patient. The court created a strict legal framework allowing passive euthanasia under the close supervision of the high courts, recognizing that allowing a peaceful death can be a part of the right to life with dignity.
Before we leave the Indian framework, we need to touch on how the courts enforce these rights practically when the state kills someone. In Nilabadi Behera, a young man was taken into police custody and was later found dead on a railway track with multiple injuries. The state tried to claim he escaped and was run over.
The Supreme Court didn't just condemn the police. They ordered the state to pay substantial monetary compensation to the mother. They established the principle that in public law proceedings under the Constitution, the court has the power to award monetary damages for the contravention of fundamental rights by the state. It's a vital deterrent against state violence.
And the court has used this power, even for non-citizens. In Chairman Railway Board v. Chandrima Das, a Bangladeshi tourist was brutally gang-raped by railway employees in a government railway guest house. The government tried to argue that since she was a foreigner, She didn't have full constitutional rights to claim compensation.
But the Supreme Court heavily relied on the Universal Declaration of Human Rights. They ruled that the fundamental right to life and dignity under Article 21, read in consonance with the UDHR, applies to all human beings on Indian soil. They ordered the government to pay compensation, affirming that basic human rights transcend national borders.
We even see the court expanding Article 21 to cover the environment. In the Research Foundation for Science case, dealing with the import of hazardous, toxic waste into India, the court ruled that the right to a clean and healthy environment is integral to the right to life. It placed an affirmative duty on the state to anticipate, prevent, and attack the causes of environmental degradation. So what does this all mean? It proves that the Indian Supreme Court treats international law not as an alien, distant concept, but as a vital toolkit. When domestic laws are silent, or when the legislature is paralyzed, the judges reach for international treaties to breathe life into the Constitution and expand protections for citizens.
Which perfectly sets up the final overarching theme for your exam. Section 6, protecting the vulnerable. We've seen how general rights apply, but international law recognizes that certain groups, due to historical subjugation or inherent vulnerabilities, need highly specialized, specific treaties to shield them.
Let's start with women. The defining international instrument is CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, adopted by the UN in 1979. We mentioned it earlier in the Vishaka case.
You can think of CEDAW as the International Bill of Rights for Women. It requires member states to systematically eliminate discrimination against women in political, economic, social, and cultural fields. It's not just about passing laws. It demands the modification of social and cultural patterns of conduct that are based on the idea of the inferiority of either sex.
Moving to children, the textbook highlights the UNCRC, the Convention on the Rights of the Child, adopted in 1989. Now, for the exam, students are required to break the UNCRC down into 4 specific pillars. Let's walk through those.
The 4 pillars of the UNCRC are crucial. The first is survival rights. This includes the child's inherent right to life and the state's obligation to ensure the child has access to adequate health care, nutrition, and a basic standard of living. The second pillar is development rights. This encompasses everything a child needs to reach their full potential. The right to free education, freedom of thought, and the right to play and leisure.
The third is protection rights.
Yes, and this is heavily emphasized. Protection from all forms of exploitation, physical or mental abuse, and neglect. A major component here is protection in armed conflicts. The convention specifically demands that states take all feasible measures to ensure that children under 15 years of age do not take a direct part in hostilities.
And the fourth pillar, which was somewhat revolutionary for the 1980s, is participation rights.
Exactly. Before the UNCRC, children were often seen merely as property of their parents or objects of protection. Participation rights recognize that children have their own agency. It guarantees the right of children to express their views freely in all matters affecting them and demands that those views be given due weight in accordance with the age and maturity of the child.
Let's discuss the rights of the disabled. The textbook outlines a massive paradigm shift in international law that happened recently. For decades, the international community only issued soft law regarding disability.
Right. Soft law meaning non-binding declarations, like the 1971 Declaration on the Rights of Mentally Retarded Persons or the 1993 Standard Rules. These documents operated under a medical model of disability. They viewed disabled persons primarily as objects of charity, medical treatment, and social protection.
But in 2006, the UN finally adopted a hard law treaty, the Convention on the Rights of Persons with Disabilities, or the UNCRPD.
The UNCRPD represents a complete ideological overhaul. It adopts a social model and a human rights model. It dictates that disabled persons are not objects of charity, but subjects with inherent rights, entirely capable of claiming those rights and making decisions for their own lives. It argues that disability is an evolving concept resulting from the interaction between a person's impairment and the attitudinal and environmental barriers constructed by society.
Article 3 of the UNCRPD outlines the core principles. It emphasizes respect for inherent dignity, individual autonomy, including the freedom to make one's own choices, and independence of persons. It demands non-discrimination, full and effective participation and inclusion in society, and crucially, accessibility, because rights are useless if you physically cannot enter the courthouse or the school building.
Now, this raises an important question that concludes our study. We have all these beautiful treaties and progressive court rulings, but who actually holds the state accountable when the state breaks the rules, especially regarding these vulnerable groups? As we discussed with the NHRC, the victims themselves often lack the money, the legal knowledge, or the physical freedom to fight a massive government bureaucracy.
This is where non-governmental organizations, or NGOs, step in. They act as the vital connective tissue between the lofty texts of international law and the gritty, dangerous reality on the ground.
NGOs act as watchdogs, researchers, and litigators. In the context of India, the textbook highlights one of the most important organizations for your exam, the People's Union for Civil Liberties, or PUCL. It was founded in 1976 by Jayaprakash Narayan during the dark days of the national emergency, specifically to defend democratic rights.
PUCL has been an absolute juggernaut in utilizing public interest litigation. We need to detail 3 pivotal PUCL cases that the textbook emphasizes. First, the right to food case.
In 2001, there were reports of severe starvation deaths in the state of Rajasthan, despite the fact that government warehouses were overflowing with rotting grain. PUCL filed a massive writ petition in the Supreme Court. The resulting years-long litigation fundamentally expanded the interpretation of Article 21. The court ruled that the right to life inherently includes the right to food. They forced the government to implement various welfare schemes, like midday meals in schools, transforming them from mere policy guidelines into legally enforceable entitlements.
Second, their fight for privacy. Long before smartphones existed, the government was wiretapping citizens.
In the 1990s, PCL challenged the archaic Indian Telegraph Act, which allowed the government to tap phones with virtually no oversight. In a landmark judgment, the Supreme Court ruled that telephone tapping violates the fundamental right to privacy and freedom of speech. They laid down strict procedural safeguards, mandating high-level review committees before citizens' communications could be intercepted, establishing a vital bulwark against the surveillance state.
And third, the Shadara mental hospital case. PUCL investigated a mental hospital run by the government in Delhi.
The conditions they documented were horrific. Inmates were naked, chained, denied basic sanitation, and subjected to physical abuse. PUCL's intervention forced the Supreme Court to step in. The court didn't just order a cleanup. They recognized that institutionalized individuals are entirely at the mercy of the state. They ruled that admission to a mental hospital does not strip a person of their inherent human dignity under Article 21, forcing a complete overhaul of the facility's administration.
NGOs like PUCL do the exhausting, unglamorous work. They gather the affidavits, they agitate the courts, and they force the state to honor the commitments they made on paper in Geneva and New York. And with that, we have traversed the entire landscape of your syllabus. We have excavated the philosophical bedrock of Greece and Rome. We have traced the blood-soaked history that led to the UN charters. We have explored the mechanics of regional courts in Europe, the Americas, and Africa. And we have deeply analyzed how the Indian Constitution, the Human Rights Act, and a relentlessly active Supreme Court weave those global ideals into domestic reality.
You now understand the mechanisms. You know why customary law binds states, how judges use progressive realization, and what triggers a human rights court. You have the tools to construct powerful arguments for your exam.
But before we let you go, and before you walk into that exam hall, I want to leave you with a final thought to ponder. We have seen how human rights are not static. They constantly expand. We've seen judges stretch the definition of life to include a clean environment and digital privacy.
But this expansion relies heavily on judicial activism, on judges creatively interpreting century-old texts to meet modern crises. Look at the horizon. We are hurtling into an era of artificial intelligence, omnipresent biometric surveillance, and genetic engineering. Technology is moving exponentially faster than any parliament can draft laws.
So the question is, where is the ceiling? When an algorithm decides who gets bail, or when a corporation patents a human genome, who will define our rights? Will the next generation of human rights be carefully debated and legislated by our elected lawmakers? Or will we be entirely reliant on judges, trying desperately to stretch the old blueprints of the 20th century to cover the bizarre new architecture of the future? When you look at the skyscraper of human rights now, you know exactly what is in the foundation. You know the legal engineering holding it up. Best of luck on your exam. You are fully equipped. Keep questioning those blueprints and keep looking closely at the world around you.